The Senate will come to order. Senator Ulibarri will lead us in the pledge.
Good morning, Madam President, guests, members of the Senate, please rise and join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Mr. Majors, would you please call the roll?
Aguilar, Balmer, Baumgartner, Brophy,
Excused?
Cadman, Crowder, Grantham, Guzman, Harvey, Heath, Herpin, Hill, Hodge, John, Johnston, Jones, Kafalis, Kerr, King, Lambert, Lundberg, Marble, Newell, Nicholson, Renfro, Rivera, Roberts, Scheffel, Schwartz, Stedman, Tokchop, Todd, Ulibarri, Zenzinger. Madam President.
Here. With 34 present, 0 absent, 1 excused, the Senate has a quorum. Motion to adopt the journal, Senator Crowder.
Thank you, Madam President. I move that the reading of the Journal of February 25th be dispensed with and the Journal be approved as corrected by the Secretary. Thank you.
You've heard the motion. All in favor say aye. Opposed, no. Ayes have it. That motion is adopted. Committee reports.
February 25th, 2014, Committee on Finance. After consideration, the Merits Committee recommends the following: Senate Bill 117 be referred favorably to the Committee on Appropriations. February 25th, 2014, Committee on Finance. After consideration, the Merits Committee recommends the following: Senate Bill 51 be referred favorably to the Committee on Appropriations. February 25th, 2014, Madam President, the Committee on Finance has had under consideration and has had a hearing on the following appointment and recommends the appointment be confirmed. Member of the Colorado Lottery Commission for a term expiring July 1st, 2017, the Honorable Charles Dennis Mace of Pueblo, Colorado, an attorney admitted to the practice of law in Colorado for not less than 5 years, appointed. February 25th, 2014, Madam President, the Committee on Finance has had under consideration and has had a hearing on the following appointment and recommends the appointment be confirmed. Member of the Colorado Limited Gaming Control Commission for a term expiring July 1st, 2017, Sheriff Douglas N. Darr of Thornton, Colorado, to serve as a member from the 7th Congressional District and a representative of law enforcement, and as a Democrat, reappointed.
Senate Services.
February 26, 2014, correctly engrossed Senate Bills 49, 114, 129, 142, Senate Joint Resolution 9, correctly revised House Bills 1005, 1008, 1050, 1083, and 1099, correctly re-revised House Bills 1024, 1059, 1079, correctly enrolled Senate Bill 67.
Message from the House.
February 25th, 2014, Madam President, the House has adopted and returns here with Senate Joint Resolution 9.
Introduction of bills.
House Bill 1028 by Representative Sonnenberg and Senator Roberts concerning a limitation on the United States' ability to impose conditions on a water right owner in exchange for permission to use land.
State Veterans and Military Affairs.
House Bill 1114 by Representatives Waller and McNulty and Senator Herpin concerning the administration of earned time by the State Department of Corrections.
State Veterans and Military Affairs.
House Bill 1163 by Representative Hollinghorst and Senator Heath concerning clarification of the cap imposed on the enterprise zone investment tax credit.
Finance.
House Bill 1184 by Representative Vigil and Senator Grantham concerning conservancy districts that are organized for the purpose of preventing floods.
Local government.
House Bill 1222 by Representative McLaughlin and Senators Schwartz and Roberts concerning modification of the terms under which a county may issue tax-exempt private activity bonds on behalf of an eligible applicant for the purpose of financing a geothermal energy project on the applicant's property.
Agriculture, Natural Resources, and Energy.
House Bill 1265 by Representative Moreno and Senator Roberts concerning the regulation of games of chance.
State Veterans and Military Affairs. Committee reports.
February 25th, 2014, Committee on Transportation. After consideration, the Mayor's Committee recommends the following: House Bill 1021 be referred to the Committee of the Whole. Favorable recommendation. February 25th, 2014, Committee on Transportation. After consideration, the Mayor's Committee recommends the following: House Bill 1065 be referred to the Committee of the Whole. Favorable recommendation.
Third reading of bills, consent calendar. Members, we're on third reading. Mr. Majors, would you please read the titles to all of the bills on third reading consent calendar?
House Bill 1083 by Representative Lee and Senator Crowder concerning the authority of a licensed acute treatment unit to receive emergency medications from certain other outlets. House Bill 1099 by Representative Schaefer and Senator Aguilar concerning prescription drugs and the practice of optometry. Senate Bill 142 by Senator Schwartz and Representative Fisher concerning an exception for certain water system facilities from the facilities that the Commissioner of Agriculture has a duty to inspect regarding pesticide storage. House Bill 1050 by Representative Kagan and Senator Guzman concerning an increase in the number of judges for the 18th Judicial District and in connection therewith making an appropriation. Senate Bill 49 by Senator Heath and Representative Priola concerning endangering public utility transmission and in connection therewith making an appropriation.
Mr. Majority Leader.
Thank you, Madam President. I move the adoption of all the bills in the third reading of bills consent calendar, which includes House Bills 1083 and 1099, Senate Bill 142, House Bill 1050, and Senate Bill 49.
Any discussion? Senator Marble.
Thank you, Madam Chair. I would like to be a no on House Bill 1050.
Okay, is there any other discussion? Are there any no votes other than Senator Marble's on House Bill 1050? With 34 ayes, 0 noes, 0 absent, and 1 excused, House Bill 1083 is adopted. Co-sponsors: Senator Aguilar, Senator Nicholson, Senators Kafalas, Newell, Todd, Kerr, Mr. Majority Leader, Madam President Pro Tem, Senator Toktrap, Senator Crowder. We'll get you down twice. Senator Lundberg. With 34 ayes, 0 noes, 0 absent, and 1 excused, House Bill 1099 is adopted. Co-sponsors: Senator Nicholson, Senator Kafalas, Senator Zenzinger, Senator Newell, Mr. Majority Leader, Senators Kerr, Toktrap, Ulibarri, Hodge, Stedman, Todd, Madam President Pro Tem, Senators Crowder. On 1099, co-sponsors Marble, Lundberg, King, Rivera, Jones, Herpin, Baumgartner, Lambert, Johnston. It's a popular optometry bill. With 34 ayes, 0 noes, 0 absent, 1 excused, Senate Bill 142 is adopted. Co-sponsors: Senator Johnston, Madam President Pro Tem. With 33 ayes, 0 no, 0 abs, 33 ayes, 1 no, 0 absent, and 1 excused, House Bill 1050 is adopted. Co-sponsors: Senators Newell, Stedman, Hodge, Todd, Johnston, Ulibarri, Mr. Majority Leader. Third reading of bills, final passage. Mr. Majors, would you please? Senate Bill 49. With 34 ayes, 0 noes, 0 absent, and 1 excused, Senate Bill 49 is adopted. Co-sponsors: Senator Newell, Senator Herpin. Third reading of bills, final passage. Mr. Majors, would you please read the title to House Bill 1241?
House Bill 1241 by Representative Duran and Senator Stedman, considering a supplemental appropriation to the Department of Local Affairs.
We're going to lay it over.
Mr. Majority Leader.
Thank you, Madam President. I move we lay over House Bill 1241 until Friday, February 28th.
For the motion, all in favor say aye.
Aye.
Opposed, no. Ayes have it. House Bill 1241 will lay over till February 28th. Mr. Majors, would you please read the title to House Bill 1008?
House Bill 1008 by Representative Hamner and Senator Schwartz, concerning the authorization of the Colorado Water Resources and Power Development Authority to make loans to private entities for purposes of forest health projects.
Senator Schwartz.
And thank you, Madam President. And I move House Bill 1008 on third reading and final passage and ask for an aye vote.
Is there any discussion? Are there any no votes on House Bill 1008? Senator Crowder, Senator Balmer. Is that Senator Hill?
Doesn't take it away.
These are no votes on House Bill 1008, third reading. Senator Baumgartner, Senator Marble. With 29 ayes, 5 noes, 0 absent, and 1 and Senator Lundberg is a no. I can't see with the people in front of you. Gotcha. Senator Lundberg, we have you as a no. Our no votes are, please add Senator Grantham. Sure. A roll call vote has been requested.
Aguilar. Aguilar, aye. Balmer. Balmer, no. Baumgartner. Baumgartner, no. Brophy excused. Cadman. Cadman, pass. Crowder. Crowder, no. Grantham. Grantham, no. Guzman. Guzman, aye. Harvey. Harvey, aye. Heath. Heath, aye. Herpin. Herpin, aye. Hill. Hill, no. Hodge. Hodge, aye. John. John, aye. Johnston. Johnston, aye. Jones. Jones, aye. Cafalis. Cafalis, aye. Kerr. Kerr, aye. King. King, aye. Lambert. Lambert, aye. Lundberg. Lundberg, no. Marble. Marble, no. Newell. Newell, aye. Nicholson. Nicholson, aye. Renfro. Renfro, aye. Rivera. Rivera, aye. Roberts. Roberts, aye. Scheffel. Scheffel, aye. Schwartz. Schwartz, aye. Stedman. Stedman, aye. Talktrop. Talktrop, aye. Todd. Todd, aye. Ulibarri. Ulibarri, aye. Zenzinger. Zenzinger, aye. Cadman. Cadman, aye. Madam President.
Aye.
Madam President, aye.
With 27 ayes, 7 noes, 0 absent, 1 excused, House Bill 1008 is adopted. Co-sponsors. Mr. Majors, would you please read the title to House Bill 1005?
House Bill 1005 by Representatives Sonnenberg and Young and Senators Lundberg and Cafalas, concerning clarification of the requirements applicable to a change of point of water diversion.
Senator Lundberg.
Thank you, Madam President. I move, or we move, House Bill 1005 and ask for a favorable approval.
Any discussion? Question is the adoption of 1005 on third reading. Any no votes?
Yeah.
With 34 ayes, 0 noes, 0 absent, 1 excused, House Bill 1005 is adopted. Co-sponsors. Senator Crowder, Senator Herpin, Senator John, Senator Zenzinger, Madam President Pro Tem, Senator Newell, Senator Todd, Senator Hodge, Senator Marble, Senator Renfro, Mr. Majority Leader, Senator Aguilar, Senator Schwartz, Senator Rivera, Senator Johnston, Senator Lambert, Mr. Majors, would you please read the title to Senate Bill 129?
Senate Bill 129 by Senator Stedman and Representative May, concerning changes to criminal provisions related to marijuana and in connection therewith making an appropriation.
Senator Stedman.
Thank you, Madam President. I move Senate Bill 129 on third reading and final passage.
Any discussion? Question is the adoption of Senate Bill 129. Are there any no votes? Senator Lundberg. Senator Marble. With 32 aye, 2 no, 0 absent, 1 excuse, Senate Bill 129 is adopted. Co-sponsors. Senator Aguilar. Senator Ulibarri. Senator Todd. Mr. Majors, would you please read the title to Senate Bill 114?
Senate Bill 114 by Senator Todd and Representatives Hamner and Holbert concerning expanding access for all students to Colorado State University Global Campus.
Senator Todd.
Thank you, Madam President, and I move Senate Bill 114 on third reading and final passage and ask for an aye vote.
Any discussion? Question is the adoption of Senate Bill 114. Are there any no votes? Senator Marble. Senator Lambert. Senator Hill. Senator Baumgartner. Senator Lundberg, I think I had you. No. These are no votes. Are there any no votes on Senate Bill 114? Senator Grantham.
Did you get a free scholarship?
With
No, I want to vote no, and I want to be taken off the bill, so.
With 28 ayes, 6 noes, 0 absent, and 1 excuse, Senate Bill 114 is adopted. Senator Lundberg.
Thank you, Madam President. I request that my name be taken off as co-sponsor.
Senator Lundberg's name will be removed as a co-sponsor. Co-sponsors. Senator Nicholson. Mr. Majority Leader. Senators Ulibarri, Johnston, Jones, Kafalas, Newell, Zenzinger. Co-sponsors. Members, under the rules, we've got an important guest with us today. I wanted to introduce and welcome back Senator Rob Hernandez. He has 2 other guests that we can't introduce under the rules at this point, but please do welcome him and his accompaniment for back to the Senate chambers. Thank you very much. And when under the rules, we'll, under a moment of personal privilege.
Senator Gibbs just.
I didn't, Speaking of former senators, we also would like to welcome back Senator Dan Gibbs to the chambers. Thank you. Members want to know where your tie is, Senator Gibbs. All righty. General orders, second reading of bills. Senator Todd.
Thank you, Madam President. I move the Senate resolve itself into the committee of the whole for the consideration of general orders, second reading of bills.
You've heard the motion. All in favor say aye. All opposed, no. Ayes have it. The Senate will resolve itself into a committee of the whole for purpose of considering general orders, second reading of bills, calendar, and Senator Todd will take the chair. Thank you. Do the stuff. Transfer. Okay.
The committee will come to order and the coat rule is relaxed. Mr. Majors, would you please read the title to Senate Bill 93?
Senate Bill 93 by Senator John and Representative May concerning equivalent authority for pipeline companies to acquire right-of-way.
Senator John.
Thank you, Madam Chair. I move Senate Bill 93, the committee report to Senate Bill 93, and there will also be an amendment.
To the Agriculture and Natural Resources and Energy Committee report.
Thank you, Madam Chair. The committee report from Agriculture. made sure that they were actually just adding language for the siting purposes and the siting of pipelines that transport the hazardous liquids. And it kind of defined it, the hazardous liquids meaning petroleum or petroleum product, non-petroleum fuel including biofuel, et cetera, et cetera. And that is what the amendment does. It is really for the siting purposes for the local governments.
Thank you. Is there further discussion to the committee report? Seeing none, is there further discussion to the bill? Oh, all those in favor, say aye. All opposed, nay. Committee report is passed. Oh, there is an amendment on the desk. Senator John? Mr.
Yes.
Majors, would you please read Amendment L005?
Amendment L005 to Senate Bill 93 by Senator John, amend the agriculture.
Thank you. Senator John?
Thank you, Madam Chair. And committee, we did pass, committee of the whole, we did pass L001, and we have to now amend that because there was some drafting errors. L005, which I move L005, fixes the errors in the committee amendment, and literally it is a technical fix with words such as is and such.
Senator Renfro?
Thank you, Madam Chair. I ask for a senatorial 5.
Senatorial 5 has been granted.
I will withdraw amendment L005.
Senator Heath. Mr. Majority Leader.
Thank you, Madam Chair. I move we rise, report progress, and beg leave to sit again.
The motion before the body is to rise, report progress, and beg leave to sit again. All those in favor say aye. Those opposed, no. The ayes have it, and the committee will rise, report progress, and sit again at 9:32. whatever time.
Pass the committee report. Okay.
Yeah.
It's progress.
The Senate will come back to order. We have no progress to report other than adding Senator Brophy to the present roll call, please. That is progress. We're happy to have you here, Senator Brophy, wherever you are. And with that, we're on general orders, second reading of bills calendar. Senator Todd.
Thank you, Madam President. I move that the Senate resolve itself into the committee of the whole for the consideration of general orders, second reading of bills calendar.
You've heard the motion. All in favor say aye. Opposed, no. Ayes have it. The Senate will re-resolve itself into a committee of the whole for purpose of considering general orders, second reading of bills calendar, and Senator Todd will once again take the chair.
All righty. The committee will come to order, and the coat rule is relaxed. Mr. Majors, will you please read the title to Senate Bill 93?
Senate Bill 93 by Senator John and Representative May concerning equivalent authority for pipeline companies to acquire right-of-way.
Senator John.
Thank you, Madam Chair. I move Senate Bill 93. And I also move L005, the amendment to Senate Bill 93.
To the amendment.
Thank you. We amended in committee with L001, and this is actually amending that amendment because we had a drafting error.
Excuse me, Senator John.
Yes, Madam Chair.
Max, will you please read the amendment, L005?
Amendment L005 to Senate Bill 93 by Senator John, amend the Agriculture, Natural Resources,
Thank you.
Energy.
Senator John.
Thank you, Madam Chair. They say third time's a charm. So, in committee, we amended L00 with L001. This is amending that amendment. We had some drafting errors, so this fixes the errors in that amendment. And with that, I ask for support on L005. I believe I moved L005.
Is there any discussion? Is there any discussion? Seeing no discussion, the motion before the body is the adoption of amendment L005. All those in favor say aye. All those opposed, no. The ayes have it, and the amendment passes. To the bill, Senator John.
Thank you, Madam Chair. So I bring you Senate Bill 93, the long-awaited pipeline bill. It is the pipeline bill that is concerning the rights of way. As you all know, in May 2012, the Colorado Supreme Court issued a decision in a case eliminating very long-established understanding law around the pipeline industry. It is in Article 5 of Title 38, based on a punctuation error in the statute. So it really is a technical fix, but per that ruling, the court had determined that the term pipeline company did not include pipelines carrying petroleum products. Therefore, we are now fixing that error that actually has been in statute for, I believe, 1907 is when the original law was written. It does not grant any new or expanded authority, which we want to keep very, very tight. Our intent is to keep it exactly the way we have operated for the past 139 years. Article 5 of Title 38 and its intent, which listed all powers of eminent domain in the same section of Colorado law and expressly referenced a pipeline company. The court's determination that the absence of a comma means this section of statute applies only to electric light pipelines. This determination is contrary to the express language enacted by the General Assembly, which I believe Judge Hobbs spelled out very, very well and explicitly in his dissent opinion to that court case. The proposed bill reaffirms historic, long-held understanding that the provisions of Article 5 apply to companies operating pipelines that transport oil, petroleum, gasoline, or other petroleum or hydrocarbon products. They will continue to pay just compensation. None of that is changing. We aren't touching any of it, as required by Article 2, Section 15 of the Colorado Constitution. It makes the statute consistent with over 100 years of practice. The pipeline companies in Colorado historically acquire right-of-way for public benefit. And for the better part of a century, pipeline companies in Colorado have used the authority granted to them by the legislature as a last resort to acquire right-of-way for their pipelines when necessary for public use. And I have to tell you that it is used very, very rarely. And it is also in statutes where there are pages and pages, and I can show those to you, of other places where the government actually has the authority to do practice eminent domain and condemnation. The facts of the case are around only refined products. That is what we are addressing. We want to address nothing less and nothing more. We are not giving unfettered power. We are literally pertaining to Article 5. And 95% of the time, which I mentioned, the negotiations are accomplished with the owner of the land. This is used very rarely. It is very costly to go to court to determine these issues, so it is to everyone's best interest to have the negotiation process. Should it go through that court process, there is a very clear statutory that literally says there must be just compensation, and it has to be approved by the court. So if it does go to court, it has to be approved that it is indeed something that needs to happen, that it is for the proper uses of the eminent domain process, and that there be just compensation, and that goes to the court. With that, I will ask for a yes on Senate Bill 93.
Senator Lundberg.
Thank you, Madam Chair. Members, there is a pipeline going through my neighborhood, and I have sat with my neighbors in meetings with the private entity that is putting that pipeline in. And here's the dilemma. Yes, eminent domain is rarely used, but eminent domain is very often threatened. It is played as a chip because you come to the table, or we can put you through the courts, and we're big and you're small, and guess who wins? That's one thing. Here's another dilemma. This is not the government. This is a private company being given the right of eminent domain. I'll certainly agree that it's a technicality that brought us to the table on this bill, but it's not just a technical tweak, it's a substantive change to the policies that these private entities can force upon citizens, property owners in the state of Colorado. Here's how it ought to work. Willing buyer, willing seller. It's called the free market. That's the way it ought to work. Now, I will grant that there are certain very limited cases where eminent domain is exercised within this country to the extent that it's a part of the Fifth Amendment of the U.S. Constitution, that the power of eminent domain is recognized only after due process and just compensation. But let's discuss the just compensation side. When one side has a big hammer and the other side has nothing, the determination of compensation is not an even playing field. And some years ago, I ran a bill to try to address the violation of the private property rights as a part of the compensation that should equal justice. That bill was shot down big time because and that was aimed at local governments and other government agencies. That was completely unacceptable because just compensation is determined this way today. Unless there is a strict law requiring more, compensation, which, by the way, eminent domain for federal highway projects does require other considerations. But just compensation is just what we can get away with. It's not what is the actual free market price. Remember this, free market doesn't mean, okay, if you put this on the market today, what it would be worth. No, free market means you've got a willing seller and a willing buyer. And here's another factor to bear in mind. When a pipeline is put in place, people say, well, yeah, but then it's buried and it's gone and it really doesn't affect anything. But it does. Because today the accepted practice is that an easement of control over the surface for what I've seen, a 50-foot swath, is what is a part of the deal. Now, that's entirely appropriate when there's a willing buyer and there's a willing seller. But when the seller is the property owner who's being forced by eminent domain to capitulate, and maybe they don't even sign the document. Maybe the court signs it for them. That's what eminent domain means, is you didn't do it, they did it to you. And I can tell you the range of compensation offered is dramatically different than the compensation that's agreed upon when there is a willing buyer, willing seller. In terms of you go to court, and let's see, the one side has a whole stable full of attorneys who are well versed in this process because they've done it so many times, and the other side is like a neighbor of mine whose husband died about 2 years ago, so she's a widow, trying to keep the home place going in the absence of her husband. I do not believe that we are setting up a system of justice, and I do believe that we have a system that can function. And I'll leave you with this final point. U.S. law with respect to eminent domain follows English common law. And here's the legal theory of this. Eminent domain is allowed because the lord of the land still owns and controls the land. And that is actually dramatically different than some other legal traditions. I understand in Japan, for example, I'm told there is no eminent domain. I know that French law, and boy, digging deep here to be quoting French law, but there the concept of eminent domain is not nearly as secure as we have in this country. I acknowledge it's a part of our legal tradition, and it's a necessary component when the government requires a road to go through that we have no other choice, or a water line where we have no other choice. But far too often, the type of programs we're talking about here are, you can go down this way, you can go down that way, maybe there's a right-of-way that's available, but the company doesn't like the terms that the government agency, the county, or possibly the state has offered. They've offered it, but it's subject to some of the other easements around there. I want you to know what you're voting on. It's more than a technical issue. It's a very important principle of where eminent domain belongs and where it does not. Thank you, Madam Chair and members of the Senate.
Thank you. Is there further discussion? Seeing none? Oh, Senator Brophy. There is an amendment on the... Senator Brophy.
Got to read the amendment.
Oh, excuse me, Max, will you please read Amendment L006?
Amendment L006 to Senate Bill 93 by Senator Brophy, amend printed bill page 6.
Senator Brophy.
Thank you, Madam Chair. I move Amendment 6. Amendment 6, ladies and gentlemen, addresses something that the previous speaker brought up. Is just, you think about this. Think about the power of eminent domain. Somebody can come to you and just take from you the use of your property. Now, it's in our Constitution. It's understandable that it exists when a necessary public good needs to find a site, some way to build a road, build a power line. So we have agreed to allow to do this. And when a public entity exercises this power of eminent domain, if they abuse the citizenry with that power, then public officials can be held accountable at the next election. So there is an element of accountability brought to this process where the citizenry can get back at a public entity that abuses this power. But let me ask you this simple question. If we allow a private entity the power of eminent domain, and they abuse the citizenry with that power, how do we hold them accountable? Is there a way? What are you going to do? You can't fire the CEO. You can't fire the landman who did this. There is no way to hold a private entity accountable if they abuse this process. And so Amendment 6, what it does is it says that in the event that these private entities have abused this process, and the abuse that I'm envisioning is something that's actually happened before. It happened on the E470 tolling authority. That public-private entity abused a farm, lowballed their bid, bankrupted them, and we ultimately found out later that the lowball was greater than 30%. They took these people's property and bankrupted them, and there was no way to hold this private party accountable for that action. And so in 2003, then Representative Sean Mitchell ran a bill that brought a measure of accountability to that private entity by saying this, that if it is found out after the fact that you have lowballed your bid by more than 30%, not only do you have to pay court damage or court costs, which is already law in this case, but you also have to pay triple damages for the difference between the actual value and how much you offered because of that lowball. It's a good idea. It is the only way to bring accountability to private entities that we are granting the power of eminent domain to. And you know what's so interesting about that? I've looked up the voting record on that, and every member of the Senate who was in the House in 2003 voted for that bill. And so that's what Amendment 6 does. It says that if you as a private entity abuse this process, there will be a penalty. And what that does is it forces you as that private entity that we have granted this power to, it forces you to make a good faith offer on the property that you're taking from an individual. That's what Amendment 6 does, and I will ask for an aye vote on Amendment 6.
Senator John.
I'm going to ask for a no vote on Amendment 6. We did discuss this in committee. It completely changes the bill. My intent with this legislation is to fix the very small portion that was in a court opinion. This completely expands the bill. That is not the intent. I believe if the good senator wants to do a separate bill to do something like that and work the bill, that he would, of course, be free to do that. This legislation is a simple fix to align Colorado law with 139 years of practice and understanding. It purposely does not change any current rights or obligations. That is not my intent. We are not creating new law, but affirming what was upset by literally a missing comma in the 19th century statute. And having sat down with attorneys that actually work in this kind of law, I will also tell you that it raises some very concerning things for me. It encourages installation of pipelines into public parks, not where we want to go. Open space and schools, not where we want to go. Regardless of safety implications or efficiencies, the amendment will force operators to place infrastructure in Colorado public spaces, creating new risks for children and general public, not where we want to go. It introduces reckless new concept of necessity, which changes the entire legal basis for condemnation proceedings, not the intent of my bill. It's very punitive, giving treble damages. You know, the Constitution is very, very clear. It says just compensation shall be ascertained by a board of commissioners, not less than 3 freeholders or by a jury. It's in section 15 of your Constitution in Article 2. It's in the Bill of Rights. So it's very specific that should it go to that point, which may I remind you, 95% of them never make it that far because there's usually negotiations. Should it go that far, it has to go through the judicial process, has to go and actually go through that, the justice system. Compensation is generally not punishment. This is clearly punitive. It's a bedrock principle of condemnation law. The judges are the ones that determine fair market value for the use of real property. So I would just ask for a no vote, and actually I have to say I think that we really need to request a ruling. Does this really fit under the title of the bill?
Put us in recess. We'll ask for a senatorial 5. A senatorial 5 has been granted. Thank you. Senate is called back to order. I rule that it does not fit under the title. Amendment L006 does not fit under the title. Senator Lundberg. Oh, excuse me, Senator Balmer was before you. I beg your pardon.
Well, thank you, Madam Chair. Well, members, I rise in support of Senate Bill 93, and there is some news to that in the sense that last year, when I was in the local government committee, I had grave concerns about this bill, and I tried to amend it, and you can talk to the members of the local government last year, and we gave this bill a hard ride. I mean, it was a tough thing. I think they had 3 or 4, I can't remember how many committee meetings we had on this bill, and it still hadn't come out of committee at that point. And so they reintroduced it later on. Let me agree with my gentleman colleague from Ray, and when he said that this bill is not a technical corrections bill, that it's a more substantial policy decision. I agree 100% that this is a substantial policy decision. I don't think it's a substantial policy change. I think it's a substantial policy reaffirmation of what the law has always been. That's the critical point here. Because a judicial decision casts doubt on what the law is, we, the legislature, are going to come in with a strong voice to say, well, what everyone thought the law was for a very long time, we are affirming that that is going to be the law going forward, and it's an important policy reason for that. Obviously, it is an easy populist target to pick on the electric light company. How many here like saying electric light, by the way? I like saying that. It's just nice and old-fashioned. I used to know people when I grew up that actually used to pay their light bill. That's what they called it, their light bill. And they used to go down to the power company to pay their light bill. And I always loved hearing that. Anyway, they are in the same category with the gas company and the pipeline companies in this bill. And why do they have this limited authority? It's because they have to have it. And they only use it in very rare circumstances. And so what I think this bill is doing, and this bill has been improved, in my opinion, from last year. They dialed it back a couple of notches. They put some changes into the bill to make it more acceptable and more fair. And so I think that's also important to note. That's why this year I'm a strong supporter for this bill. And I think that we need to make sure, this is one of those times when the legislature needs to come in and tell the entire world that indeed we want to keep the law the same that it's always been. And so this bill is a policy decision. It is not a technical corrections bill, but it is a policy bill affirming what the law has always been, that we want to keep the law the same. So I really appreciate the opportunity, Madam Chair, to speak in front of my distinguished colleague from Berthoud, and I hope that you will call on him next.
Senator Lindberg.
Thank you, Madam Chair. Members, at the risk of repeating myself, I will repeat myself.
And we will listen.
And that is because I'm the one who was the state senator who did sit with his neighbors and listen to the concerns they had when the company said, we are going through your property. And I'm the one who heard them say, well, they told us that they've got the power of eminent domain, so I guess we have to come to the table. I'm the one who listened to the county officials saying, well, we'll allow them to go down the right of way on the road. And that was rejected by the company. And I'm the one who understands also that these are necessary components to our infrastructure, but the weight of the argument shouldn't be solely on the back of the individual property owner. And that's the way it's been until this court decision that determined, well, it's not quite worded right. So that therefore, now we have before us the question posed again. And as the a good senator from Centennial spoke. It is a significant policy decision that we have the choice of reaffirming or rejecting. Think very carefully. I'm not here standing up on behalf of anybody but the citizens of Senate District 15 in Larimer County. And I've spent untold hours in the last year on this very issue with those citizens. The way it needs to be is willing buyer, willing seller. The way this bill puts it up, the big boy gets all, which is not a government agency. As a matter of fact, these are at times companies that have a monopoly, and I believe that shouldn't give them more authority. That should give them more responsibility, because the government has said you can operate exclusively. That does not give them the power of eminent domain when it comes to these pipelines. It should not, in my opinion. I believe that we need to stick with the system as it currently exists, which is to require more of the willing buyer, willing seller. Now, I'm also very well aware that to leave it as is doesn't make it perfect, because there's still too much threat of eminent domain placed on the part of private homeowners. That's not appropriate. I recognize that this bill has kind of a fast track. That's the way it strikes me, that it's set up to succeed. But please listen very, very carefully and weigh this through the eyes of those who elected you. They are the ones who will pay the price when it comes through their neighborhood.
Senator John.
Thank you. And I do want to just address one thing, because number one, in this building, I have never, ever fast-tracked anything, and this is no different. This bill went through a committee hearing, in fact, was laid over so that everyone would have a chance to weigh in on it. So it has been very slow going through the process, and I have been very patient with that. I think it's important that we don't fast-track things and that we give everyone the opportunity to speak that wants to speak on an issue, and we've certainly given that time in committee, as well as laying it over so that everyone would have a chance to participate. And so it has been a very, very fair process, and I would prefer not to say that it had been fast-tracked. Thank you, Madam Chair.
Senator Jones.
Thank you, Madam Chair. Well, members in committee, I want to tell you a little bit about what went on in our committee. We had an epiphany. We had a Weld County Commissioner, Commissioner Kirkmeyer, in alignment with Boulder County officials as well. And then they mentioned also Adams County. And the reason they all have concerns is because this is a private entity condemning land for hydrocarbon gas pipelines. And there's a lot of concern about giving that kind of power to a private entity, and all you have to do is look at the handout. The Larsons, who were in the Supreme Court case with Sinclair, were at the hearing. And I know you probably can't see this, but this is an aerial photo, and it has a crop circle here, and that's the Larsons property, and it goes through this subdivision called Rolling Hills Subdivision. It goes right through the middle of it, very close to houses. And they wanted to put a second pipeline in there, and that was the issue that went to the Supreme Court. And the Supreme Court said, no, you can't. You don't have the authority to do that. And you've never had that authority, the way this is written. And that was what the proponents or the opponents of the bill were saying, is that these folks never had this authority in the first place, even though they'd been using it, because it had never gone to trial. And it's a bit of a David and Goliath thing. It's Sinclair Oil versus the Millers, who are farmers. We just confirmed their son, actually, to the, what? To the Groundwater Commission. And I just think this kind of a power in a private entity is a stretch, and we ought to be very, very careful. And I think we should stay where we are with these kinds of products, especially because they're so volatile and they can go through neighborhoods, and they literally do. It's hard to find the easement where they did not build a house. It's so close. And so there's a real safety issue where private entities can go right through and condemn private entities and not have oversight. I mean, if you do that in a public environment, people can go to the ballot and unelect you. There's no kind of check on this kind of power. So I'd ask for a no vote on the bill.
Senator John.
Just for interesting reading, I found this very interesting. We even give these rights to cemeteries, which I found fascinating as I was doing my research, and would encourage all of you to pull up 381202, because it very specifically talks about how the following types of corporations and persons. So it's not just government that can do this, but there's pages and pages, if you look at this, on who is allowed right this minute, right now, in our laws to do the eminent domain. So it's everything from tramway companies to cemeteries to transportation. It is just all over the board in here. So I really encourage everyone to pull up 381202. Very interesting reading.
Is there further discussion? Senator Senator Rivera.
Thank you, Madam Chair. In listening to the debate as we have here, as well as discussion of the bill on the floor previously and with the folks out in the lobbies and so on, I find the points they make to be very interesting. We've had this described, everything from just a minor clarification with the punctuation at fault because of court ruling that's kind of thrown us into this quagmire. I've also heard from the senator from Berthoud, who indicates and how critical this issue is. And I've also heard from the bill sponsor once again how it's all over. I mean, the number of folks that are granted the ability to get eminent domain is throughout these statutes at this point in time. But I guess that's what makes this bill critical, is the fact that through a court ruling, because of a punctuation error, this Senate has the opportunity to say, okay, we got a lot of folks out there that can do eminent domain, but is that good? Is that good? And I think that's the crux of it, and that's why we're having this discussion. The folks citizens are out there are, I believe, from discussions with my constituents, are concerned about the powers that the government has and the fact that they can, in fact, do eminent domain. Just this last couple of years, we've been having the problem down there in Pueblo, or the issue, let's just say the issue, of eminent domain related to the SDS pipeline. Eminent domain was used in order to run the pipeline, and that's water, to get the water from Pueblo Dam onto Colorado Springs. So, although, once again, this issue was brought up by a punctuation error, maybe that's a good thing. The good thing that folks can have an opportunity to maybe just put a little bit of brakes on what has been considered, well, that's just what government does, and that's what it is, and a lot of folks can do it, so no need to change the law. Well, there is an opportunity to do that. And so I would ask for no vote.
Senator Schwartz.
And thank you, Madam Chair, and I rise in support of the bill and just would like to speak to The fact that we were able to, I think, put in an important amendment on the bill relative to the fact this bill is really focused on the right-of-way of refined product pipelines, hazardous fuel pipelines. These are pipelines that carry benzene, jet fuel, things that we don't want in trucks or trains that can be delivered more safely. But more importantly, the siting of those pipelines is a local process, and it has to go through and be subject to local regulatory process for the siting. And the construction oversight is, especially in the hazardous pipelines, is something that the federal government oversees. But most importantly, that the local entity, whatever that jurisdiction is, must have hearings and a public process that will, in fact, review and approve the siting. And if those resources are not available to that community, the amendment speaks to the fact Department of Local Affairs will assist that community in identifying resources for them to address safety and the risk associated to avoid having any hazardous fuel pipeline underneath a public facility, a school, a community in the future. That is why siting is so critical. And to the extent that we are now simply focused on this very narrow subset of pipelines that the authority needs to be given to, since the crude products already have the authority in statute.
Is there any further discussion? Senator John?
Thank you, Madam Chair, and I would just ask to close. I think that our senator, our good senator from Centennial, really hit on the crux of this when he spoke about the history and kind of where this process has been. Number one, I think that whenever we are talking about eminent domain, and I have been a huge property rights supporter in my 12 years, whenever we're talking about eminent domain, I believe that we need to keep that very, very narrow. But I believe it is something that is also something that needs to be there. I believe in our statutes and our state constitution, we have put parameters in place. I believe that we have safeguards. And I think that's critically important for the protection of the citizens of the state of Colorado. I think Judge Hobbs, when I studied the case that's been talked about so much today, I think he said it the best. I think he made his point very, very clear, and I have so much respect for him because of the knowledge he carries in this particular area and water. And I've listened to him for the years, and I just think he's incredibly smart. But he was on the dissenting side, and I think that he just really hit the nail on the head, and I want to share with you his comments. He said, I won't read all of it, but the last portion, the historical record amply demonstrates that the General Assembly's intent in enacting the pipeline company portion of Section 38.5.105 had a great deal to do with regulation of petroleum pipelines. The purpose of our General Assembly, like several state legislatures beforehand, was to give independent oil producers a chance to compete by countering the anti-competitive tendencies of large petroleum conglomerates operating under the umbrella of the use of words pipeline company. In its 1907 enactment, it occurred amidst a Colorado oil boom at the very height of a populist movement countering Standard Oil's dominance. Prior to the 1907 Act, the General Assembly had already defined pipeline companies as conveying gas, water, or oil. It reinforced this definition in 1907 with more comprehensive language in pipeline companies, not limited to electric pipeline companies, as possessing the eminent domain power. Petroleum was the main target of the 1907 Act. I think he just really spells it out, and he certainly spells out my intent of why I agreed to carry this legislation. Yes, I think that we need to always have the consumers' safety at the forefront, but I believe that we have done that by holding firm to our Constitution and to the state statutes of where this law is. So with that, I will ask for a yes vote on Senate Bill 93.
Is there any further discussion? Seeing none, the motion before the body. Oh, I'm sorry, Senator Lambert. My peripheral vision didn't work this morning.
Thank you, Madam Chair. I thank the sponsor for the thoughtful discussion of eminent domain. But one of the, I think, constitutional definitions we have to keep going back to is what is public use? Is the public really using the land? And that has been interpreted differently for as long as the country's been in existence. Everything from postal roads to interstate commerce and whatever. And I think there are different situations where the government has declared eminent domain for things like railroads. The Union Pacific, for instance, was a taking by the federal government to, force through certain rights of access for a private company, but it was a government action. But looking at that historically, there are other alternatives that actually worked better, that did not violate the rights of Indian territories, did not violate private property rights, that actually went out and purchased land based upon market values, like the Great Northern Railroad that went up through northern United States and Canada, and as a result didn't have all of the conflict that we had, especially in the American experience with Native American tribes who resisted the use of eminent domain. But the question is there a legitimate public use? Or should we allow, as in the Senator from Berthoud's case, to negotiate what is a fair market price for that private land? I prefer the latter. I think that we need to consider the long-term consequences of government intervention to distort prices by taking land, and we have to understand, is this a legitimate public use? Not just necessarily a public good, but is the public actually using this particular right of access? I think this particular case, when we are limiting this, as I understand the bill, to gas pipelines, but not oil pipelines, I don't see the legal distinction between the two. And yet this bill preferentially apparently targets gas pipelines for inclusion, but oil pipelines not for inclusion. If you're making a case about public use, I think it would be an equivalent, should be an equivalent standard, but it doesn't seem to draw that distinction. So on that basis, I still have a lot of questions about the bill, so I'll have to be a no vote today, but I'm concerned anytime we try to redefine or add more to the constitutional definition of public use, and I'm concerned for the long-term consequences of that, it may not be, as in those examples of the two railroads, it may be better, it may be more peaceful, it may be a better and actually more economically sound system to let the market values determine that private property right and go in that direction. Thank you, Madam Speaker. Madam Chair.
Is there further discussion? Seeing none, the motion before the body is the adoption of Senate Bill 93. All those in favor say aye. Aye. Those opposed say nay. No. The ayes have it. The bill is passed. Mr. Majors. Mr. Majority Leader.
Thank you, Madam Chair. I move we rise and report.
The motion before the body is to rise and report. All those in favor say aye. Those opposed, no. The ayes have it, and the committee will rise and report.
The Senate will come back to order. Senator Todd.
Thank you, Madam President. The committee has met and had one bill under consideration. Mr. Majors, would you please read the report?
February 26, 2014, Madam President, your committee of the whole basic report is under consideration of the following attached bill being the second reading thereof, makes following recommendation thereon. Senate Bill 93 is amended, passed on second reading, and ordered and engrossed, placed on the counter for third reading and final passage.
Is there any discussion on the committee of the whole report? Senator Brophy.
Thank you, Madam President. I move a roll call vote on Senate Bill 93.
Okay, before we proceed to vote, is there any other discussion on the committee report? Seeing none, the roll call vote has been requested on the committee of the whole report, which is what we're on. So the question for the body is the adoption of the committee of the whole report. Roll call has been requested. Mr. Majors, please take a roll call on the committee report. It's one bill.
Part of the bill can be voted on specifically inside the report. My understanding. We've done that before.
Mr. Majors, would you please poll the senators?
Aguilar. Aguilar, pass. Balmer. Balmer, aye. Baumgartner. Baumgartner, aye. Brophy. Brophy, pass. Cadman. Cadman, aye. Crowder. Crowder, aye. Grantham. Grantham, aye. Guzman. Guzman, pass. Harvey. Harvey, aye. Heath. Heath, aye. Herpin. Herpin, aye. Hill. Hill, pass. Hodge. Hodge, aye. John. John, aye. Johnston. Johnston, aye. Jones. Jones, aye. Kafalis. Kafalis, aye. Kerr. Kerr, aye. King. King, aye. Lambert. Lambert, no. Lundberg. Lundberg, no. Marble. Marble, no. Newell. Newell, aye. Nicholson. Nicholson, aye. Renfro. Renfro, aye. Rivera. Rivera, no. Roberts. Roberts, aye. Scheffel. Scheffel, aye. Schwartz. Schwartz, aye. Stedman. Stedman, aye. Tocktrop. Tocktrop, aye. Todd. Todd, aye. Ulibarri. Ulibarri, aye. Zenzinger. Zenzinger, aye. Aguilar. Aguilar, no. Brophy. Brophy, no. Guzman. Guzman, aye. Hill. Hill, no. Madam President.
Aye.
Madam President, aye.
With 28 ayes, 7 noes, 0 absent, and 0 excused, the committee of the whole report is adopted. Senate Bill 93 is amended, passed on second reading, and ordered, engrossed, and placed on the calendar for third reading and final passage. Consideration of House amendments to Senate bills. Mr. Majors, would you please read the title to Senate Bill 52?
Senate Bill 52 by Senator Crowder and Representative Sonnenberg concerning actions taken to remediate soil erosion creating property damage.
Senator Crowder.
Thank you, Madam President. I move the Senate concur with the House Amendment SB 52.
Thank you. Would you explain the House change?
Yes, ma'am. The change basically is line 27, page 3, which puts a cap on the soil conservation dust belonging situation. And it's just, it's a cleanup on it, and this was what was wanted in the Senate, and they got it in the House. So, you know, I do concur with the House amendments. I have no problem with it.
Any discussion on the motion to concur? Senator Brophy.
Thank you, Madam President. I would urge an aye vote on this motion to concur. This is the reason that I voted against the bill when it left this chamber was that there was no cap on what a government entity could charge somebody for mitigation of dust. The cap has been put on over in the House. I think this really is a good bill, a necessary improvement to the existing statutes, and I'll ask for an aye vote.
Senator Crowder?
Thank you, Madam President. I move for the repassage of Senate Bill 52.
All right, let's take up concurrence first. Are there any no votes on concurrence to House amendments to Senate Bill 52? With 35 ayes, 0 noes, 0 absent, 0 excused, the Senate concurs with House amendments to Senate Bill 52. Senator Crowder.
Thank you, Madam President. I move for readoption of Senate Bill 52.
Any discussion? The question is the repassage of Senate Bill 52. Are there any no votes? With 35 ayes, 0 noes, 0 absent, and 0 excused, Senate Bill 52 is readopted. Additional co-sponsors. Senator Rivera, did you want to make sure you're a co-sponsor? We'll just make sure. You are a co-sponsor. Senator Schwartz is a co-sponsor. Senator Todd, you are now going to be a co-sponsor. Senator Nicholson, you already are. Senator Roberts, you already are. Signing of bills.
February 26, 2014, the President signed Senate Bill 67. February 25, 2014, the President signed House Bills 1035 and 1086.
Committee reports.
February 25, 2014, Committee on Local Government, after consideration of the Mayor's Committee, recommends the following House Bill 1052 be amended as follows and as so amended before the Committee of the Whole. Favorable recommendation with the recommendation to be placed on the consent calendar. February 25, 2014, Committee on Local Government, after consideration of the Mayor's Committee, recommends the following House Bill 1112 be referred to the Committee of the Whole. Favorable recommendation with the recommendation to be placed on the consent calendar.
Message from the House.
February 26, 2014, Madam President, the House has passed on third reading and transmitted the advisory statutes House Bill 1254 and 1188. The House has passed on third reading and transmitted the advisory statutes House Bill 1034 is amended, 1082 is amended, 1191 is amended, 1210 is amended. The House has voted to concur in Senate amendments to House Bill 1074 and has repassed the bill as so amended.
Delivery to the Governor.
To the Governor for signature on Wednesday, February 26, 2014 at 8:03 a.m., Senate Bill 67.
Announcements. Senator Todd.
Thank you, Madam President. May I ask for a moment of personal privilege, please?
Granted.
Thank you. I just wanted to give a quick reminder that today is Realtor Day at the Capitol. The lunch program begins at 11:30 at McNichols Building at Civic Center Park. The McNichols Building is located on Civic Center Park at southeast corner of Colfax and Bannock. And approximately 200 realtors from across Colorado have come to the Capitol today. So when you see them, thank them for helping the economy grow and get those homes sold and relocated, getting people relocated in Colorado. Thank you.
Senator Crowder.
Thank you, Madam President. Just a reminder, Colorado Health Institute hosting a health policy lunch and learn today. That's in SCR 356. So I hope to see you there. Thank you.
Senator Newell.
Thank you, Madam President. Members, remember today is Cinema Day at the Capitol. We will be having in the West Foyer, we will be having a film crew of Colorado professionals that are hosted by the Colorado Film and Video Association, and you can go down there with your staffs if you would like and get dressed up and be on the green screen, so to speak. And then we also have an event tonight, which is Film After Hours, a Cinema After Hours mixer to celebrate the incredible successes that we've had over the incentives that we've had for the film industry. So that's today, 11 to 2 in the West Foyer, and tonight at 5 to 7.
Senator Kerr.
Thank you, Madam President. I'd like to ask for a moment of personal privilege.
Granted.
Thank you. Want to remind all the members that Monday is a very special birthday. It's the birthday of Dr. Seuss. And of course, there is the Read Across America program that celebrates Dr. Seuss's birthday every year. So find a classroom full of children, find a couple of Dr. Seuss books, and plan to go in and read some Dr. Seuss books to those kids. It's a great program, encourages reading, and really helps celebrate the life and legacy of Dr. Seuss. Thank you.
Mr. Majority Leader.
Thank you, Madam President. Members, let me, and colleagues, let me just give you a heads up for next week. We all know that we have caucuses next Tuesday night on March 4th. And we also know that I think all of us are going to want to attend those caucuses, and obviously a lot of you have a long ways to go. So next Tuesday, we will proceed as normal in the morning, but we will not have any committee meetings that afternoon. So when we adjourn Tuesday morning, we're all free to head back to home so we can attend our caucuses. And also, the following morning, March 5th, for your planning purposes, we will not convene until 10 a.m. So you're going to get numerous reminders of that, but for your planning purposes, we thought we would give you a heads up so you can make certain that you are going to be able to attend your caucuses. In terms of committees, today they are meeting as scheduled. Tomorrow I am asked to announce that the Senate Ag, Natural Resources and Energy Committee will not hear House Bill 1026. I know Senator Schwartz wants to make sure that everybody understands that so witnesses don't come. So Ag Committee will not hear House Bill 1026 tomorrow. With that, I don't see any other announcements. I move that the Senate adjourn until Thursday, February 27th at 9 a.m.
You've heard the motion. All in favor say aye. Opposed, no. Ayes have it. The Senate will adjourn until 9 a.m. tomorrow, Thursday, February 27th.
Thank you.